How do you plead in each of these third-degree felonies, guilty or not guilty?
Not guilty. Guilty.
Hold on, you got a not guilty followed up by a guilty. What's your final answer?
Guilty.
Okay, yeah.
Number 17, Court of Anthony Heights, 23586.
Alex Kowalski from people. You missed a vision. Okay.
Good afternoon, Judge Slay. Brandon Burkett on behalf of Mr. Eisen. And Mr. Eisen, would you
Mr.
identify
Eisen,
yourself?
if you're driving, you better pull over right now.
If it's what? Oh, jeez.
Mr. Burkett, we can recall your case when your client's not driving.
Certainly, Your Honor.
I'm not driving.
You're currently not driving or you weren't driving? Choose your words wisely.
I put in my drive. I was pulling in my driveway.
Okay, Mr. Burkett?
Yes, Your Honor. How are you today, Your Honor?
Wow, thank you. How are you doing?
I'm trying to make it. Your Honor, I filed this motion, and I filed a corrected one last week and notified the prosecutor where we're asking this court to dismiss this case and or grant an evidentiary hearing. Your Honor, after I received the answer to my motion to the prosecutor, I think this court can decide this case without an evidentiary hearing. Now, in our favor, my client, Ms. Eisen, is charged with assaulting, resisting, obstructing a police officer, causing injury. Now, our defense to this, Your Honor, is this. We went through the regular channels to get all the discovery that the government had, and the prosecutor did give us everything except one videotape of the incident, but he did send us the videotape in the answer to this motion. But our position is it doesn't matter. It doesn't make any difference. Our first issue, Your Honor, is this.
Sure, I'm done. Oh, I'm sorry.
May I go ahead?
Go ahead.
Yes.
Mr. Burkett.
Thank you. Your Honor, the police officer stopped my client for not having lights. They took him out of the car and they patted him down, searched him and put him through a sobriety test and all that. At some point, he broke away from them and ran. And as a result of him running and them searching for him, the officer is claiming an injury. And we take issues with all of that because we're saying that what they're asking for is not consistent with Michigan law. First of all, the assault that they're talking about, the only thing we have from the prosecutor is her report. Her report never mentions any type of assault that ever took place in this case. Never said that she was ever assaulted by this person. And as this court is well aware, an assault requires an offensive touching. That never happened in this case. He never touched her. He just broke and ran from her.
That's a battery though, Mr. Burkett, not an assault, not a reasonable apprehension of an immediate battery.
I'm sorry, I didn't hear you.
So that, you just gave me the definition for battery, not assault though.
An assault requires the offer, the threat to harm. He never did that. He never did any of the requirements that requires an assault. And the prosecutor never even argues that, yeah. And they so much as admit that. The other thing I want to bring to your thing, Your Honor, which I think is very important in this case, is that the officer claims while searching for him that she stepped into a pothole and injured herself. Well, we asked him if that is the case, then we need to see some documentation. As I put the records that they gave us for the documentation, Your Honor. Now, keep in mind, this happened in November. The documentation they gave us was for January when she went to the doctor. There's no history of this, she claims she injured her elbow. There's nothing to show the history of how she injured her elbow. It's just that she injured her elbow. That's not sufficient. We are entitled to know, was that injury related to this case? And we simply said it's not. And Your Honor, and the most important thing about this whole incident is this, that in our paragraph, we stated that the officer at no point ever told my client that he was under arrest. They pulled him out the car, they searched him, they wanted to put handcuffs on him. He broke and ran. Now, the prosecution's position is, well, he should have known he was under arrest. No, Your Honor, there you're flirting with due process. He has an absolute right to know that he's been under arrest, or he kept asking, why are you putting handcuffs on me? She wouldn't tell him. She wouldn't tell him he's under arrest. At that point, he broke and ran. And we said that's not obstructive. And the case that I cited to you, Your Honor, is a case that's directly on point. So, yes, People versus Moran, which was, I think I quoted in my brief to you, Your Honor, 491 Michigan 13. It's cited by the Michigan Supreme Court. Case almost identical to this. The police tried to arrest this person. They went to his house, and he said, well, I'm not going to let you in. Slammed the door on them, and they was injured. And the police went back and said, we sent somebody downtown to get a search warrant to come in your house. And he said, well, you don't have it now, and slammed the door on them again. They said, well, that's obstruction of justice, obstruction. It went all the way to the Supreme Court, and the Supreme Court says, no, that's not obstruction of justice. That's an illegal arrest. You had no business doing that. Same thing here. They had no business stopping this man, putting handcuffs on him, and not telling him that he was under arrest or why he was under arrest. And our position is that doing all of that, they violated all of his rights, and that this court should either dismiss or quash the information, or suppress it, I'm sorry.
Thank you, Your Honor. Judge, just for the record, we had sent Mr. Burkett notice of the entirety of the body camera right around the beginning of December. I included an excerpt from that because it was too big to email to the court, showing the 15 seconds or so that is directly at issue. There's 7 different ways you can violate the statute, and clearly the defendant did at least 3 of them by opposing, battering, resisting, obstructing, endangering a police officer. If the court wants to, if the court wants to find that there wasn't an actual assault, certainly, the way that the defendant said, you're not arresting me, or something to that effect, and I'm paraphrasing, and threw his arms up, it's resisting. I'm not aware of any case law in Michigan that says that someone who is, 3/4 to 90% of the way through an OWI investigation has to be told they're being placed under arrest. That may go to whether or not he knowingly did something, but that's a different question. Certainly there's enough to go forward to trial. As far as the injury, the only records that we were given from the officer at this time was the follow-up report from January. I asked for records showing, what any records she had, that's what she had available to her at the time. And it described a fracture to her elbow, which was reflected in the report. I think there's certainly enough evidence for this case to go forward. I ask you to deny the motion.
Questions of fact or the providence of the jury, while questions of law are reserved for the courts. Since the parties are not come to a consensus as to the facts, I'm not inserting myself. Neither one of you have waived a bench, so this has to go in front of a jury. And it's up to the jury to determine the questions of fact. That's under People v. Kohenek, 491 Mich. 382 and 411 of 2012 case, and People v. Lennon, which is 456 Mich. 625 at 637 in 1998 case. The defendant's motion is going to be denied. It sounds like there are some discovery issues that need to be attended to. Mr. Burkett, if they are not resolved, you should file a motion regarding a discovery demand. Hopefully you two could just work that out. At this point, would you like another pretrial hearing or are we setting this to trial?
Probably a pretrial to see if we can. She's out.
How much time would you like, Mr. Burkett?
I'm sorry, I didn't hear you.
How much time would you like?
Couple of weeks anyway. I'm trying to look at my calendar now, Your Honor.
The 12th or the 26th? Those are our options.
The 26th of,
February.
that will be fine, Your Honor.
Okay, 26th of February it is, Mr. Isom, sir. We will see you back then.
I'll prepare an order, Judge.
Your Honor, thank you. Have a good day.
Who's the attorney on Ashley Grant? You ready?
Send it to your attorney. I need to swear her in.
Come on in, ma'am. And she'll swear you in. Thank you.
Over here.
Right over there. This one.
Ms. Grant, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the true self you got?
Absolutely.
Okay, you got your right thumbprint. You can place it down flat on that box right there. You get up again, one more time. Place it down flat right there.
Both third-degree felon.
Right, show in front of judge.
She's pleading to 2. 23 CR 662 is called. State of Texas versus Ashley Grant, who is charged with a third-degree felony of obstruction or retaliation. And 23 CR 960 is also an indictment charging Ashley Grant with a third-degree felony of harassment of public servant. Does the defendant waive formal readings of these indictments? Can we proceed in summary?
Yes, Your Honor.
In summary, 662 alleges that on or about March 4th of 2023 in Jefferson County, Texas, you committed the third-degree felony of obstruction or retaliation involving a public servant, namely a police officer. Do you understand what you're charged with there?
Yes,
In 960, this alleges on or about February 18th, which was two weeks. No, I'm sorry. Yeah, about 2 weeks prior to the event in 662, that on February 18th, 2023 in Jefferson County, Texas, this charges you with the third-degree felony of harassment of another Beaumont police officer. Both of these are third-degree felonies. Do you understand what you were charged with here?
yes, sir.
In each of these cases, if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreements have been reached in your cases where you would be pleading guilty, placed on deferred or unadjudicated probation for 10 years on each case. Is that your understanding of the agreements?
Yes, it is, sir.
If I follow these agreements, you have no right of appeal. Do you understand of your cases? How do you plead in each of these third-degree felonies, guilty or not guilty?
Not guilty. Guilty.
Hold on, you got a not guilty followed up by a guilty. What's your final answer?
Good,
Okay,
guilty.
yeah. Are you pleading guilty voluntarily in each of these cases? And because you are indeed guilty of these offenses?
I'm guilty.
All right, I show you what's marked as State's Exhibit 1 in each case. Did you
Okay.
sign those documents
Yeah.
voluntarily? Did you understand them?
Yeah,
Discuss them with your attorney? Are the
Yes.
contents all true and correct?
that's correct.
State's Exhibit 1 tendered into evidence in each of these cases.
Objection.
Without objection, they are admitted. Among other things, State's Exhibits 1 in each case state succinctly that you are mentally competent to enter your guilty pleas, which are freely and voluntarily made. You understand what you're charged with. The indictments have been read to you. You've read them. You were guilty of the crimes charged in any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. So help you God in each case. Is that so?
Yes.
State's Exhibit 1 is made a part of the record in each of these cases. How much time in jail? I guess have you been in jail since you were arrested?
Yes, sir.
Stand by. Boy, I'm looking at 662. I can't believe that kind of language from a lady
Oh.
you used. And to a police officer, who works for you. That's and me.
Yeah, I feel that. Got you.
And then here in
Not yet.
960, you're shouting obscenities to the officers. My goodness. And it looks like you were maybe under the influence of an alcoholic beverage.
Yeah, I dropped one time.
That doesn't make it right.
Judge, for some reason, her jail card is not updated, so I don't have an accurate count of how many days she's been in jail. Let me look real quick on her warrant screen and see when that was closed out.
I'm worried. I'm more concerned about 960 where she spit on the officer on his face.
Okay, let me check that one, Judge.
You're gonna be that's intolerable. Well, they have to face that kind of thing, but you're going to be held responsible when
Yeah.
poor behavior like that, which is unsafe behavior
Yes, sir.
under. In each of these cases, while we're figuring out, you have pleaded guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty pleas in each of these cases from State's Exhibit 1 to find you guilty beyond a reasonable doubt. But I am going to rather defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years on each case. There will be terms and conditions of probation which are normal and customary for this.
Looks like August the 1st of 2023, she was arrested, Judge.
Type of offense. I'm sorry, in 960 what?
Looks like she was arrested August the 1st of 2023.
You've been in custody since August?
Yes, sir.
You will serve 60 further days as a condition of probation and 960 for that very dangerous activity that you performed on one of the public servants. You don't spit on anybody, much less a police officer.
No, I would ask her attorney if she's not saying this, but I would request the court to abate that since she has done 6 months already. If the
Not as a condition of probation. She hasn't. It says they put her in at August 24th is when it's showing. August 1st. So that would be, but
6 months as of.
But I think I can put 6 months as a condition of probation from the outset of probation.
You can, you're absolutely, everything right. I'm just asking the court to consider.
It's just, let me just say this. I'm just going to say this. You don't spit on the people who represent you and me and who are putting their lives on the line. You don't spit on their face.
No.
That carries a price. And anything else? That is all. Who else do I have?
Here, so that,